A constitutional framework that stood for 114 years just collapsed in a single afternoon. The Supreme Court's 6-3 ruling didn't just strike down one state's gun law. It detonated the entire permit system that 9 states used to deny firearms to 70% of ordinary Americans while fast-tracking approvals for celebrities, retired cops, and the politically connected. Before you click away, hit that subscribe button because what I'm about to expose will fundamentally change how you understand your Second Amendment right. The case that shattered everything, the case that shattered everything. The lawsuit that brought down America's oldest gun control system wasn't filed by some massive lobbying organization with unlimited resources. 2 ordinary New York residents, Robert Nash and Brandon Coe, tried to get concealed carry permits and were flatly rejected because they couldn't prove they faced special danger beyond what any other citizen experiences. Nash had completed firearms safety training, passed every background check, and had a completely clean record. Yet, a licensing officer denied him because wanting to protect yourself wasn't considered good enough reason. These rejections weren't unusual. They were standard operating procedure in New York since 1911 to decide whose constitutional rights deserved protection and whose didn't. The New York State Rifle and Pistol Association took their case all the way to the Supreme Court. And in June 2022, Justice Clarence Thomas wrote the majority opinion that obliterated this 111-year-old gatekeeping system. But here's the part that legal experts are still trying to fully comprehend. The court didn't just rule against New York's specific law, the constitutional test that rewrites everything test that rewrites everything. The Supreme Court created an entirely new legal standard that automatically invalidates thousands of gun regulations across America without requiring separate lawsuits for each one. The text history and tradition test now forces prosecutors to prove that any gun restriction has a clear historical analog from the 1790s founding era. And modern crime statistics, public safety arguments, and polling data are completely irrelevant under this framework. Federal judges in California spent months searching through historical archives trying to find evidence that colonists ever limited magazine capacity, and they came up empty because ammunition feeding devices didn't even exist in the forms being regulated today. A federal court in Illinois struck down the state's assault weapon ban after prosecutors couldn't produce a single example of founding-era Americans banning specific rifle configurations based on cosmetic features like adjustable stocks or pistol grip. The historical burden is so impossibly high that the Congressional Research Service estimates over 300 state and federal gun laws are now constitutionally vulnerable under this new test. But while legal scholars debate the scope of this new framework, something even more dramatic is happening on the ground in real time. The permit explosion nobody expected. Hawaii had issued exactly 187 active concealed carry permits to civilians across the entire state before the Bruin decision. That's 187 permits for a population of 1.4 million people, which calculates to an approval rate of approximately 0.01%. Within 8 months of the ruling, Hawaii processed over 3,800 new permit applications, and approval rates in Honolulu County alone jumped from essentially 0 to 82% for applicants who met basic training and background check requirements. California's permit numbers tell an even more shocking story. Los Angeles County, which had issued roughly 400 permits countywide despite having 10 million residents, suddenly faced a backlog of over 8,000 applications within the first 6 months after Bruin. New Jersey, which had maintained one of the nation's most restrictive systems by approving only 1,200 permits statewide annually, saw application numbers surge past 45,000 in the first year post-Bruin. The financial impact on state governments has been equally dramatic. New York's permit processing system, which previously handled maybe 5,000 applications per year across the entire state, suddenly got crushed under 60,000 plus new applications, forcing the state to hire 87 additional licensing staff members at a cost exceeding $4.2 million annually. The malicious compliance strategy. California responded to losing at the Supreme Court by implementing SB 2, which designates nearly every public location as a sensitive place where concealed carry is prohibited, effectively rendering permits useless throughout 90% of the state's urban areas. The banned locations include any building owned or leased by government entities at any level, all public transportation systems and stations, every park and playground, any property within 100. All entertainment venues, including movie theaters and stadiums, libraries, medical facilities, banks, and financial institutions. And most bizarrely, all private property, unless the owner posts explicit signage permitting firearms, which virtually no business does. Legal analysts mapping out San Francisco's restricted zones discovered that a permit holder legally cannot carry their firearm continuously for more than 3 city blocks in any direction before entering a prohibited area, making lawful carry functionally impossible. New York's response was equally aggressive. The state passed emergency legislation creating 23 categories of sensitive places and requiring permit applicants to submit 3 years of social media account information for review, essentially deputizing licensing officers to deny permits based on political speech or opinions they find objectionable. But there's one category of gun laws facing an even more existential threat right now. The billion-dollar industry facing collapse. The firearm training and permit processing industry generates an estimated $1.3 billion annually through mandated courses, application fees, fingerprinting services, and renewal requirements. And Bruin is systematically dismantling the regulations that prop up this entire ecosystem. California's 16-hour training mandate costs applicants between $200 and $400 depending on location. And with over 100,000 new permit applications filed post-Bruin training facilities collected approximately $25 to $40 million in fees within the first year alone. Maryland requires 16 hours of classroom instruction plus live fire qualification at state-approved ranges, generating roughly $18 million annually from training fees when you calculate the state's typical application volume. But federal courts are now questioning whether states can constitutionally mandate expensive training requirements that didn't exist during the founding era when Americans could purchase firearms without any government permission, background checks, or safety courses. A pending lawsuit in California argues that requiring 16 hours of training at $300 plus cost creates an unconstitutional financial barrier that prices out low-income Americans from exercising their Second Amendment right. And if successful, this challenge could eliminate mandatory training requirements nationwide. The permit processing industry is watching nervously because constitutional carry laws have already eliminated their business model in 29 states. And if courts strike down training mandates in the remaining states, the entire billion-dollar ecosystem collapses overnight. The 300 lawsuits reshaping America. Legal scholars tracking federal court filings have identified 312 active lawsuits challenging various gun laws under the Bruin framework as of October 2024. And the outcomes will determine whether Americans face strict regulations or constitutional carry nationwide within the next 5 years. 18 separate lawsuits across 7 states are challenging laws that prohibit 18 to 20-year-olds from purchasing handguns, arguing that 18-year-olds could buy firearms during the founding era and even served in militias with their own weapons. Federal courts in Minnesota and Oregon are reviewing lifetime firearm bans for nonviolent felons, with judges questioning whether a 55-year-old man who committed check fraud at age 23 should permanently lose constitutional rights when historical evidence shows founding-era Americans rarely imposed lifetime weapons bans for nonviolent crimes. California's 10-day waiting period is being challenged by a gun owner who already possesses 17 registered firearms and has passed 17 separate background checks, with his attorneys arguing there's zero historical justification for forcing someone to wait when the state already knows he's legally qualified to own guns. Illinois' assault weapon ban, enacted after the Highland Park shooting, is being challenged on grounds that the state cannot ban firearms in common use by millions of Americans, and the case could reach the Supreme Court by 2026. Gun rights organizations have collectively filed over $87 million in legal challenges since Bruin was decided, and they're systematically targeting every category of restriction that cannot meet the historical analogs test. The Supreme Court has already agreed to hear one major Second Amendment case in its upcoming term, and legal experts expect the justices will need to clarify exactly how far the Bruin standard extends. A decision that will either cement the most significant expansion of gun rights in a century or preserve what remains of America's gun control framework. OUTRO: the Supreme Court handed gun owners the most significant constitutional victory in modern American history,